I'm glad you could join me again on another edition of Handy Law. We will continue with the series on Nigeria's Administration of Criminal Justice Act of 2015, in conjunction with the Administration of Criminal Justice Laws of Lagos, Ogun, and Kaduna states. Today, we will look at the provisions for searching arrested persons. Whenever a person has been arrested by a police officer, the police officer making the arrest may search the person, using such force as is reasonably necessary for the purpose, and place in safe custody the articles found on the person, except the clothes the suspect is wearing. If a suspect is admitted to bail and bail has been provided, such a suspect shall not be searched unless there is reasonable ground to believe that he has the stolen item, instruments of violence or poisonous substance, tools used for committing the offense which is suspected to have committed, and any other article that may be used as evidence against him. Whenever it is necessary to search a suspect, it must be by a person of the same sex, unless the urgency of the situation does not make it practicable to do so, in which case the search must be carried out with all decency. An inventory of the items recovered from the suspect must be taken, and the police officer taking the inventory must sign along with the suspect. However, failure of the suspect to sign will not invalidate the inventory. A copy of the signed inventory must be given to the suspect's lawyer. Where property has been taken from a suspect, the police officer may, upon request by the owner of the property or someone who has interest in it, release the property on bond, pending the appearance of the suspect in court. However, if the police officer does not release the property to the owner or someone who has interest in the property, he must make this fact known to the court. The court at this point may order that the property, a portion of it, be released to the owner or that person with interest, if he deems it appropriate in the interest of justice. If, on the other hand, property is taken from a suspect and the suspect is not charged before a court, but released for insufficient reason to believe he committed an offense, the property must be returned to him, as long as that property is not connected to or proceed of an offense. Where a suspect in custody is charged with committing an offense of such a nature that there is reasonable ground to believe that an examination of his person will provide evidence to prove he committed the offense, the police officer may ask a qualified medical professional or a certified professional with relevant skills to examine the suspect using such reasonable force as is necessary to ascertain the facts. But in Lagos and Ogun states, where a medical practitioner is not available, a police officer may examine the suspect, or a person acting in good faith with the help of a medical professional, maybe over the phone or using whatever technology they may choose to employ, may examine the suspect to ascertain the facts. Where a person or a police officer acting under a warrant of arrest has reason to believe that the suspect entered a particular property, the person who lives in the property or the owner, upon request, must allow the police access to search the property for the suspect. If the person who lives in the property is a woman who should not be seen in public, the police must give her notice to withdraw before entering the property to search. On the other hand, if the police officer is a woman, she does not have to give notice to the person who lives in the property to withdraw. She can enter and search for the suspect. Where the police is denied access, they are authorized by law to break a window or a door to gain access into the property. So if you don't want your property damaged, allow them access. This is where we will end today's segment. Still looking forward to your comments. In the meantime, don't forget to like, share, and subscribe.